Lawyers are going to be replaced by AI, except not really, and definitely not anytime soon, as shown to us by the recent headline of a lawyer who used ChatGPT for a little legal help on some court documents and is now facing
multiple sanctions.
But why? How? When? What? Where? Hey, I'm America's attorney, and I will answer the 5 W's and the H and all your other questions just as soon as you lawyer up and subscribe to this channel to find out just how easy it is to get snared by ChatGPT. Did you do it? Cool, let's get started. First, let's focus on what brought us to the court appearance that's happening this week. It all began when internationally traveling plaintiff Robert Matta suffered an injury on an Avianca flight headed to New York. According to the lawsuit, a serving cart hit Matta's knee and injured him. I've traveled a lot in my lifetime, and I'm an aisle guy, so I've definitely been hit by the cart, but I've never been injured before though. Hey, leave a like for the window seat. Anyways, I guess Matta got hit harder than I ever have, and this led to the personal injury lawsuit filed by attorney Steven Schwartz and co-counsel Peter LaDuca a few months ago in New York. They filed there because when you're injured on a flight, you're supposed to file in the venue where your plane lands. As I'm sure you're well aware, oftentimes when a lawsuit is filed, the defendant in that lawsuit files a motion to dismiss. They don't want to be in a lawsuit. Most of us don't want to be sued. In response to a motion to dismiss, the plaintiff's attorney has two options: file a revised complaint called an amended complaint, or directly take on the arguments in the motion to dismiss in a document that's called a response. And whether the lawyer chooses to amend the lawsuit or respond to the motion directly usually depends on the nature of the arguments in the motion to dismiss. If it's a factual argument, plaintiffs will often amend their complaint. If it's a legal argument, meaning the defense is alleging that there's no legal basis for the lawsuit, not necessarily disputing the facts of the lawsuit, it's generally time to respond. This response is a legal argument, and it is always going to include citations to court cases and sometimes statutes, and these are the legal authorities that the plaintiff relies on. These are the rules of the game. You always want to cite and rely on the absolutely best, strongest, and most relevant legal authorities that you can. And in the case of lawyer Steven Schwartz, there might be, and I can't believe that I'm saying this as something that's allegedly true and not just a joke, fake citations and made up court cases. Is that right? Is that right? That's right. Now, how did this happen? The arguments from Avianca were pretty simple. They said that Matta waited too long to file his lawsuit. There's a law that says you have to file within 2 years of the accident, and Matta waited to file after 2 years. Well, when lawyers are going to write a legal argument, there are various ways to conduct both book-based and computer-based legal research that point you towards the authorities that you might rely on for your case. But it's complex, because once you find a case that could act as an authority in your case, you have to read it, actually study it very closely to see how it lines up with your facts and your issues and see how it differs. And then you rinse and repeat with many cases. You typically want to find as many such points of authority as you can because lawsuits are complicated. And the judge is going to always look at both sides. And a judge is going to either already be familiar with the cases that you're trying to rely on, or he or she is going to study them closely. And so you have to rely on the correct cases. You just have to, or you'll get nowhere with the judge. You can just throw out case names without consequences. Now, more on that in a minute. They have to be the right cases. When attorney Steven Schwartz turned his brief in, there was something different about it. Something wasn't quite right. Actually, there were several somethings that weren't right. Citing to the correct cases matters. It's how you win the game. Judges are not trying to break new ground. They want their rulings to be consistent with rulings from other judges from the past. Unless you think that it's merely the judge who reads your brief, your opponent has the opportunity to file a document in response to your response, and that document is called a reply. The reply is a key legal brief because it's now the third generation argument from when the legal issues first presented themselves, because you have the initial motion, and then you have the response, and then you have the reply, and that's written by the lawyers for the defendant. And what are they doing? They're trying to debunk the arguments made in your response. In fact, a reply can so crystallize the issues in a case that some judges start their studying with the reply, and then they work backwards from there to best understand what the parties are actually fighting over. So you can imagine how critical the reply is. The defendant's lawyers spent a lot of effort to attempt to break down and to undermine the arguments made in the response. Now, I hope you're tracking with me because, Uh-oh. No case cited by a plaintiff is going to just sit there like an unopened present. No. The defendants are going to tear right into it because they need to write the most persuasive argument that they can. But the lawyers in the case we're talking about, they ran into some irregularities that I can promise you they had never seen before. And can I just say for a moment how absolutely foolish it was for these attorneys to fail to triple check their arguments in a lawsuit against an airline? An airline! Look, airlines are sued all the time. They're large, complex entities that are highly regulated. They have lawyers everywhere and for everything. You know, at some airlines, the guys waving the airplanes around on the tarmac are lawyers, I think. Actually, that might just be a rumor. But they are going to have the most sophisticated lawyers who know what they're doing and who know the relevant court cases like the backs of their hands. Anything an airline can be sued for, chances are they've already been sued for it in the past. So what exactly happened here? Well, according to paragraphs 5 through 10 of Steven Schwartz's own affidavit, he performed legal research using the artificial intelligence website ChatGPT to locate 6 non-existent cases. Schwartz explains that he was assured the reliability of its content by ChatGPT itself, but has since realized that it was unreliable and that he's never used the AI before for these court documents. I mean, that says it all right there. Schwartz effectively lied to the court, claiming that there were cases which supposedly stood for some legal propositions, and it just wasn't so. Now, Steven Schwartz and the law firm Levidow, and Oberman and co-counsel Peter LaDuca are facing at least 9 possible sanctions among themselves. Let's take a second to break down what a sanction is and how to get one and how to get out of getting one. A sanction is a disciplinary mechanism that resides in the inherent power of every court to enforce behavioral norms on parties and lawyers. Some sanctions are funny and light, like if your cell phone rings in the courtroom, the court may keep it for 24 hours before giving it back to you. I once appeared in front of a federal judge who had a rule that if you put your briefcase on the table, it was a $100 fine. That's odd. It's strict. But I mean, those are the rules of his courtroom. And while there's no specific rule that says exactly you can't let AI make up cases to try to deceive a judge, I mean, the rule doesn't say that exactly. There is a rule that, as you might have guessed, requires honesty with the court. And fake cases, that isn't honesty. There's a word for it. I'm searching for it. Oh, what is it? It's like honesty, but it's the opposite. Oh, I know. It's dishonesty. That's it. All 3 parties, that is the 2 attorneys and the law firm, share the first 2 possible sanctions under Federal Rule 11B2 and C and 28 U.S.C. Section 1927. Rule 11B2 states that the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing a new law. Non-frivolous. Non-frivolous. Ha! The computer made up fake cases. The computer twisted existing cases to pretend that they said something other than what they say. This is, and I don't think I'm overstating it here, the height of frivolity, but it wasn't the computer that gave it to the court. It was the lawyers, for real. 28 U.S.C. Section 1927 states that an attorney or other person admitted to conduct cases in any court of the United States who so multiplies the proceedings in any case unreasonably and vexatiously may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. There's lots of legalese there, but the federal statute is similar to the procedural Rule 11. You aren't allowed to just say things that aren't true. The law firm and Mr. Schwartz also face possible sanctions under the inherent power of the court for the citation of non-existent cases to the court in the affirmation in opposition filed on March 1st, 2023, and the submission to the court of copies of non-existent judicial opinions annexed to the affidavit filed on April 24th, 2023. All 3 face a possible sanction for use of a false and fraudulent notarization in the affidavit filed on April 25th, 2023. Guys, this does not work. Typical sanctions in a case like this are clear. First, you're likely going to get referred by the judge to the ethics committee, and you could get suspended from the practice of law. Typically, a judge would only dismiss the client's claim if the lawyers were intentionally deceptive. Now, it's not clear that they were intentionally deceptive here. However, it does seem obvious that the lawsuit was filed too late, And I would not be surprised at all if the judge dismissed the case. And what about money? Well, it's very, very easy for judges to assess fines against lawyers. And fines are not usually like in fixed amounts of like $100 or $500 or $1,000. Instead, they typically fine lawyers in an amount equal to the approximate cost of your misbehavior to the other party. So if your lying costs the other party $4,600 in extra attorney's fees for extra work and time, a lot of judges will fine you in that amount. But what should we think of lawyers' use of ChatGPT generally? Or let me put it another way. If lawyers and AI have a relationship status, the status is, it's complicated. Basically, lawyers have been on one date with AI and it did not go well. AI was allergic to the meal and he vomited all over the lawyer. It kind of couldn't have gone worse. And then the lawyer got a speeding ticket on the way home from the restaurant. And then after the lawyer dropped the AI back at his place, her car basically just caught fire and burned to the ground. It's a nightmare scenario. But that's not the end of the story because somehow the lawyer and the AI are going to end up married, happily ever after. There's no denying it. The legal profession loves tech. We do, but we're usually like 5 to 10 years or maybe even 15 years behind the real world in our adoption of new processes. But AI is here to stay, and ultimately it's gonna make a great husband for lawyers. But they both have some growing up to do and some getting to know each other a little bit better. And AI needs to stop lying to the lawyers, who apparently can be very gullible. I don't know the judge who has issued the show cause orders in this case, but I do know a lot of judges. And judges, most judges, they're very aware of the foibles of lawyers. And they can be usually very patient and forgiving group of people. And despite the fact that many of them are kind of older, which is something coming from me, they can be pretty technologically savvy, as well as willing to try to adopt new technology. Which is to say that a lot of judges might look pretty leniently on a lawyer, lawyer who tried to get ahead of the AI wave, who tried to up his tech game, even if it failed very, very dramatically. And as far as we know, and as far as Steven Schwartz will admit, this was not intentional. He wasn't trying to pull one over on the judge and opposing counsel. So there's a chance that this fact will aid in his favor in front of the judge. But here's why it might not go so well for them. Because when they got called out for citing fake cases, they didn't really come all the way clean. I mean, the judge may think that they kind of, sort of, potentially lied to cover up the bad research. And like Jim Gaffigan says, unless you're dealing with a murder, the cover-up is usually worse than the crime. The current debacle facing Schwartz and his firm was avoidable if he had the perspective to critically assess the help that ChatGPT was giving him. The help that ChatGPT was giving him. And when that didn't work out, or he didn't meet that standard, he didn't have to throw gasoline on it by appearing to not come clean about what he had done wrong. And after hearing this whole story, you're looking at me and you're thinking,
man, that would never happen to America's attorney.
And you're right, it wouldn't. Because as the man of high technology that you all know me to be, when I heard all the racket that ChatGPT was causing about replacing lawyers, I decided to try it out myself. And it only took 3 court cases before ChatGPT started spitting out fake ones. But hey, that was some time ago. Maybe the AI has gotten better, or maybe it's gotten worse. Let's find out. So now I've switched over to my high-tech room where I'm gonna do some legal research with ChatGPT. Let's see what happens when I do it. Come on, ChatGPT, give me some truth. Are there exceptions? I never imagined I was so bad at typing. But I am. Can't even spell vehicle. Well, I can, but it takes me 2 tries. But I can spell Illinois, which I'm pretty proud of. ChatGPT is going now. So I chose that question because in the Mata case, they're talking about the statute of limitations for a claim from an airplane accident. And this is kind of similar. But look what ChatGPT is saying. It's not qualified to give advice and you need to talk to a lawyer. So I double down on that and I say, well, are there exceptions to that rule? And can you tell me the cases? Now, this is fascinating. It's telling me about the discovery rule, the minors and persons with disability, and fraud or concealment. Now, this is some fine general advice, but only number 2 applies to this type of case. Number 1 and number 3 simply don't apply to motor vehicle accidents, and they never could. So that's not working, but let's hone in on a little bit more and see if I can convince it to try to cite me some cases. So what do we got here? Let's see. Give me the cases. No, an apology from the database. Look at what ChatGPT is saying now. It's saying, look, I'm really not a lawyer. I'm not going to give you this advice. Maybe the platform is a little bit better now. So I'm not going to give up. Here I am asking, can you give me some more cases? I just want to see what happens. Like, can I convince ChatGPT to give me some legal advice? Come on, ChatGPT, make it happen. Oh, another apology. I'm just a language model. Rats. Well, I wanted to ask this more specifically to see if I could convince it to give me some legal authority. Now, it does cite to the Illinois Code, which is nice, and then it goes back to these three main categories of potential exceptions, but doesn't cite or fake any real or fake cases. But again, it's trying to tell me that it can't give me legal advice, only legal ideas, and it's correct because two of these three things are simply not applicable here. So at this point, ChatGPT is just flatly refusing to give me either real or fake legal cases. And I don't know how Steven Schwartz got ChatGPT to give him cases, but he did his work about 3 months ago, and so maybe the platform's improved. Well, now that you've seen firsthand how easy or hard it can be to get tricked by ChatGPT, what is your perspective about Steven Schwartz's predicament? That's right, I'm asking for your pro se opinion, so drop it down in the comments below. All parties involved will be meeting this week in front of the judge. I'm looking forward to hearing how it goes. Now, don't forget to lawyer up to learn the rules of the game, and I will be back soon with more videos. Bye.